Evening and welcome to the USIBC monthly legal digital roundup with Khaitan and Company. We are really pleased today, as usual, to have a group of experts from the legal community. We plan to talk through a number of pressing and interesting topics that have occurred over the last, 3 months or maybe 2 months in this instance. And I just want to let you know that this event will be recorded. We will also share the slides. Before we get going and I hand it over to our able MC, Tanu, I just really want to thank the Khaitan and Company team. The material they put together is truly insightful. I know our members appreciate it. And so I just want to thank you all in advance as we get going. With that, I'm going to hand it over to Tanu to kick us off. Over to you, Tanu.
Thanks, Jay. Welcome, everybody, to another round of our digital economy roundup. We run this in a newscast format, and the reason we call it newscast is because we cover several different legal updates in different areas of law in one session. Our Khaitan team here and different team members here are your correspondents today. I'll quickly introduce the speakers for today's session. We have Sudipta Bhattacharjee first. Sudipta is a partner in our indirect tax practice. He's based out of Delhi. We then have Supratim Chakrabarti. Supratim leads our data privacy practice. He's based out of Kolkata, but I think he travels around the country a lot. So, we then have Shobit Chandra. Shobit is part of our telecom practice based out of Delhi. We have Nishad Nadkarni. Nishad is a partner in our IP practice based out of Bombay. We then have Sumantra Bose. Sumantra is also part of the data privacy and technology practice. He's also based out of Calcutta. And finally, at the bottom left, there's Ishan Jory. Ishan is based out of Bombay. She's a technology and media expert. And then there's me, of course. I'm also a technology and media lawyer based out of Bombay. But for this session, I'll be the moderator. Quick look at the agenda for today. If we could slide to the next one. We'll start with some latest amendments in the online gaming space regarding GST. Our partner Sudipta will cover that. We'll talk about business impact of the Digital Personal Data Protection Bill, which just got approved. The most hotly talked about topic at the moment. Supratim will cover that. Shobit will talk to us about TRAI's recommendation, which is the Telecom Regulatory Authority of India. TRAI's recommendations on AI. Ishan will take on from there. She will talk about TRAI's consultation paper on OTT communication services. She'll also talk about the recent cinematograph amendment bill, which recently got approved by the Rajya Sabha. Nishad will talk to us about some guidelines issued by the Advertising Standard Council of India. And finally, Sumantra will close our segment today with the update in the cybersecurity space. With that, I'm very excited for today's session. There's been a lot of activity in the last couple of weeks, and so this will be a good session. I'll hand over to Sudipta to kickstart our first segment. Over to you, Sudipta.
Thanks, Tanu. Welcome, everyone. There's a famous line, there are decades when nothing happens and weeks when decades happen. That fits really well in the context of this slide. GST in the context of online gaming, not much had happened in the last few years, and certainly in the last 6 to 8 months, a lot has happened, but we'll start from ground up. Under the Indian Constitution, there is a clear fundamental right to earn a living on the basis of one's skill, right? And it is under the Freedom of Trade and Commerce Clause, and it is in that context that from the 1950s onwards, the Indian Supreme Court has repeatedly highlighted and emphasized the difference of games of skill and games of chance. Games of skill are kosher, games of chance could be prohibited by law. The Freedom of Trade and Commerce does not extend to game of chance, also referred to as betting and gambling. It is in this context that one needs to understand the position of GST authorities since 2022, wherein they took a position that wherever there was a wagering on outcome of a particular game, it should be taxed as betting and gambling, even if it is a game of skill. So an online game of rummy, if played for monetary stake, should be taxed as if it's betting and gambling. Now, of course, this clashes with a lot of Supreme Court and many High Court judgments. And in the landmark case of Gamescraft Technologies from Karnataka High Court a few months back, a $2.6 billion GST demand was quashed against Gamescraft Technology based on this particular narrative. Parallelly, the GST Council, which is the highest constitutional body in India for GST-related policy making, they have also been deliberating on the GST applicability vis-a-vis online gaming, casinos, horse racing, so on and so forth. In the last month, in two meetings held, one in last month and one last week, they have come up with a large set of amendments, proposed amendments to the GST law, wherein they have recommended a 28% GST levy on online money gaming. The way it is sought to be defined, it will cover the real money gaming sector, wherever players deposit money, money's worth in the expectation of winning, irrespective of skill or chance. So here, legislatively, they want to obliterate the particular difference. And more importantly, the taxable base. So far, online gaming players in India, they pay 18% GST only on the platform fee or on the gross gaming revenue, and not on the entire GMV, not on the bets placed, monies wagered on their particular platform. The proposal is to do just that. Thankfully, after a lot of pushback, a lot of representations from the industry, the government has conceded, the government has clarified that while GST would be levied on the initial deposits made by player in the online gaming platform, there will be an exclusion for winnings from the games that are redeployed by players for further gameplays. So at least that part is out, which is a significant sigh of relief. Although even in this format, even when the GST at 28% is being proposed to be levied at on the amount of deposits, a lot of smaller players are expected to bleed and shut shop. One has already, right after this announcement came out, one has already said that we'll have to liquidate. We foresee a fair amount of that happening, especially for smaller players. In terms of implementation for these recommendations, bear in mind these are recommendations and these are not binding on the states or the center. This will require all the 29 states in India as well as the central government to amend the GST legislations, rules, and notifications for this to become a law in force in India. Because GST, the way it is designed, they move in lockstep. The state and the center have to move in lockstep to implement this. The target implementation date for these amendments is 1st of October. We'll have to see whether all of these processes will get over by that time. Because there was, especially in the last meeting, massive amount of pushback from two states at least, or three states, the state of Delhi, the state of Sikkim, and the state of Goa, against some of these provisions, seeking reconsideration of some of these recommendations. The government has promised a review of these recommendations 6 months after these get implemented. And the last point in this regard is whether these amendments, when they come in, will they be retrospectively applicable? Will they go back to July 2017? The Revenue Secretary has clarified that formally, technically, these will not be retrospective, but he has also added the quota that these are clarificatory. They merely clarify the position as it always was, at least in the minds of the revenue authorities. To my mind, that's more of a strategic decision because they don't want to admit that in the past period, or the law as it stands today, it does not allow levying GST on online games of skill, online platforms where skill games are being played, to be taxed as akin to betting and gambling. Because they have now reached Supreme Court in appeal, the government of India has appealed before the Supreme Court. The appeal is still lying in defects. The last time I checked, they probably want to preempt that sort of argument from our side. So that is what has happened, and over to you, Tanu.
Great, thanks, Sudipta. That's very helpful. But just before I, wrap up this segment, how reasonable do you think is this target implementation date of 1st October?
Highly ambitious to my mind. There are 29, legislatures will have to act before 1st of October, and there are quite a few states which have already, pushed back against this. So I foresee some amount of extension. Also, I'm hearing murmurs that the various gaming federations, they will formally seek a extension because they said that, we need to align our business processes, etc., vis-a-vis these new rules. So 1st October seems a little unlikely.
Right, great market insight as well. Thanks, Sudipta. Thanks very much. We'll move on to our next segment. I'll invite Supratim now, who will talk about the recent data protection bill. Over to you, Supratim.
Yeah, thank you, Tanu. I hope I'm audible.
You are.
You're all
So
right.
I think so right after the Lok Sabha passed the Digital Personal Data Protection Bill. Of course, there's a lot of flutter and people want to know what happens next. And logically, the next step is it goes to Rajya Sabha, then it goes to the president for assent, and then it gets notified in the Gazette, and then we have the law in place. So what we understand is that there is a lot of political will that this goes through, and very soon probably we'll have this law in play. So what we did was we started speaking, to industry bodies, organizations, etc., and try to find out that what could be their immediate concerns, issues, pain points, or aspects that they are talking about. We are, of course, at USIBC doing a lot of sessions, but for purposes of this particular discussion, we thought that we'll just talk about some key aspects and what industries are really concerned about, what they're preparing for or thinking of preparing for. I think the first thing that everyone's talking about is the negative list approach to cross-border transfer of data, which is a welcome move. And also there has been a clarification that if there is a stricter law in this regard, that should prevail. I think we had a lot of confusion that suppose, for example, the Reserve Bank of India's diktat on payment systems related data, which cannot go outside the country. And then you have this law which said that if there is this law and another law, then this law should prevail. So what happens in such a situation? I think so that clarification has been brought about. Also, another important thing is in relation to this whole issue of deemed consent, which was there, which has now gotten rebranded to certain legitimate uses, I think, to give it a more global color. But if stuffs like voluntarily given personal data, or if a data is given for employment purposes, medical emergency, etc., that would fall within that kitty. Institutions are trying to figure out which all elements could fall into that kitty and how it can be utilized. Then you have a number of things where organizations are trying to get prepared on. And the primary one, I think, is notice and consent. Because a lot needs to be done as far as Indian organizations are concerned. They do not take consent in the manner it is really specified. For example, it should be specific, it should be informed, unconditional, unambiguous, and then there is this whole overemphasis on specified purposes. And if you see that illustration that is given there, that has been a cause for concern for some industry players. It is mentioned that if there is a telemedicine app and the telemedicine app has taken consent for providing telemedicine services and also ask for access to the entire phone contact, then that consent which has been taken in relation to processing all the phone contact details, that is auto expunged. So I think this aspect is a little critical one for every organization, especially those in India. The other point that we wanted to discuss in relation to consent is the age schedule translation that is required. So your notice and consent has to be translated into 22 languages, which is quite a rigorous task. Also, you have to keep evidence of notice and consent. Again, something that as you are setting off with this law, organizations will have to prepare for. Data protection, data principal related rights, of course, is something Indian institutions are not fully, prepared for or even can envisage. So therefore, that activity, including, starting off with data mapping, is something that institutions and organizations started thinking on. Having a DPO, if you are a significant data fiduciary, having a data protection officer in India is something that you need to think of. And otherwise, also the grievance mechanism and a person akin to a data protection officer needs to be there. And last point I'd like to mention here is valid contracts. Ordinarily, right now, we do not have a hard-coded requirement of having a data controller and data processor related contract. So this particular law has now called it out very specifically. So Indian institutions need to now look at their agreements. Of course, some of them who are following the global gold standards are fairly comfortable that they will sail through, but others need to look at their agreements and probably recraft some of those. So that's all from my side. We have a lot to speak about, but we thought that we'll keep it snappy for the purpose of this session.
Thanks, Supratim, and clearly lots to do for everybody on the data side all over again. I'll move on to our next segment. Shobhit is going to talk about AI, which is, I think, a hot topic across the globe at the moment. Over to you, Shobhit.
Thank you so much for that, Tanu. And as you rightly said, I think these recommendations by the TRAI have come at a very timely juncture, especially when the world is really getting enamored and captivated by the possibilities that AI presents. So these recommendations are obviously instrumental in the sense that they provide how best can AI be leveraged in the telecom sector. These recommendations are a culmination of a request that the DOT had made to the TRAI for examining the various possibilities of adopting AI in several facets of telecom and impacting various stakeholders. To start things off, I think TRAI has also understood the challenge of defining AI in a very efficient manner. And in fact, what they've said is that AI is an umbrella term that includes any type of software or hardware component that supports machine learning, computer vision, and natural language processing, robotics, etc. Therefore, there is no globally accepted definition of AI. It is obviously a very fluid term, and in today's day and age, it can really encompass a lot of things and limitless possibilities. But speaking of why it is essential to regulate AI, what TRAI has laid emphasis upon is the fact that there are challenges relating to bias, where because based on certain information that AI systems are trained and often educated, there can be a result where for certain individuals, there is a degree of bias. And for example, if you're processing a loan or if you're trying to seek financial assistance, there could be a fair degree of information relating to you available in public domain, which may give an unfavorable result in certain circumstances. So there is a fair degree of bias. There could be lack of explainability and accountability as well. And this again hinges from the fact that AI is constantly learning, and it sources its information from various platforms and different websites. We've seen that happening even in the case of ChatGPT of late, where there have been instances where inaccurate information has been cited, and there's really very little accountability for that. Also, there are possibilities of surveillance when it comes to adoption of AI, and there has been much talk about how that can trample upon human rights and cause a lot of abuse in that respect. And lastly, TRAI has also recognized the fact that there is a fair deal of misinformation as well as disinformation that could be floating around, and which is why it becomes important to uphold the safety, privacy, and integrity of data. So these are basically the cornerstones of why there is the need for a regulatory framework for this at this point in time. And in this regard, there are also certain models that have been talked about by TRAI and how effective they can be in regulating this. And the first of which are self-regulation. And TRAI has sort of noted that this may not be the most effective means of regulating, especially because the self-regulatory bodies are generally kept at a distance from the garb of the government, and they can't really, enforce the provisions as strictly as they'd like to. There is also a suggestion to be regulated by the Artificial Intelligence and Data Authority of India. Now, there is a proposal to rechristen the existing Data Digitization and Monetization Council as the AIDAI, and this would perform both regulatory as well as a recommendatory role for furthering the cause of AI in India. Similar to a role that TRAI plays in the field of telecom and broadcasting, so where it adopts a role which is both regulatory and advisory in nature. There's also talk of adopting a risk-based approach, taking a leaf from the book of EU and the recent law that has been sort of rolled out there, of course, which is yet to take effect. But there is a possibility of doing a risk-based regulation depending on, what kind of use cases there can be, and high-risk ones will, of course, have a more firm degree of legal obligations. There is also talk of a multi-stakeholder body encompassing members from various government departments and ministries, as well as industry bodies, industry members, as well as experts in the field of AI. And all of these would then be advising AIDAI in its functioning. Moving on to the hallmark of how AI can be important and why it is really important to have availability of data in this entire process. And because data is the basis of training and validating AI models, there should be a more streamlined approach to making data more available and accessible to entities. And as a corollary to that, of course, there is the need for enacting a data protection law, which has become essential in today's day and age. And of course, with the passing of the DPDP bill in Lok Sabha, it has obviously provided a lot of bolster to that. There is need for establishing AI infrastructure as well to help enterprises grow and carry on with their efforts. And just moving on to the specific use cases that have been suggested in the field of telecom, and these are mainly towards telecom companies adopting AI for subscriber verification purposes, for DOT, for the DOT's Telecom Security Operations Center for network security, for monitoring grievance redressal in the public grievance system, also for effective management of spectrum. We have seen this happening in the recent past with regard to commercial communications, where the use of AI and machine learning was suggested by TRAI for curbing spams and, of course, for improving quality of service. So obviously, the possibilities are limitless, and it'll have to be seen how this really shapes up. Thank you so much.
Thanks, Shobit. Thanks for that. We'll move to our next segment. We have Ishan Johari. She does a lot of work both in the OTT and the cinema space. So, best person to cover both of these segments today. Over to you, Ishan.
Thanks, Tanu. Got that. So the first segment that I'm discussing today is the TRAI's consultation paper on regulatory framework for OTT communication services. TRAI issued this paper last month. And just to give you a brief background, the Department of Telecommunications had also previously sought certain recommendations from TRAI in 2020 regarding regulation of OTT communication services. At which point, TRAI had recommended that market forces must be allowed to respond to the situation and without prescribing any regulatory intervention. Now, at this juncture, TRAI has again issued this consultation paper for stakeholders to provide their comments regarding various issues in the OTT sector. The first key issue that the TRI has asked for comments for is the definition of OTT services vis-a-vis OTT communication services. As TRI has pointed out, OTT services is a broad gamut of services which are provided over the internet and includes voice, video, instant messaging, e-commerce, content streaming, etc. Whereas OTT communication services is a further subset of OTT services, and these are defined more as services which are same or similar to that provided by telecom service providers. So TRI typically wants to focus more on OTT communication services while determining its regulatory framework, and therefore has sought comments from stakeholders in order to crystallize a definition around this, and also to create an underlying principle basis which different OTT services can be classified. On licensing and regulatory framework, TRI has noted that the telecom service providers in India are regulated under the Unified License regime, which requires an eligible entity to procure relevant authorizations under the Unified License. Telecom service providers typically have several legal obligations like interconnection charges, tariff protection, transparency in billing, restrictions on sending unsolicited commercial communication, etc. All of these obligations and all of these authorizations are not applicable to OTT communication service providers, and therefore there is a sense of disparity between the two players. In view of this, TRI has sought comments from stakeholders to see what is the proposed licensing and regulatory framework that can be implemented on this aspect. The fourth point that TRI has highlighted in the consultation paper is a collaborative framework. Given that internet protocol has split content and carriage, there is a lot of interdependency between network operators and OTT service providers. And therefore, TRI has sought comments on collaborative ways of commercial arrangements between these network operators and OTT service providers, such that network service providers can leverage the demand that consumers have for data in order to operate their OTT services. The fifth and fairly the most important aspect that TRI has touched upon in its consultation paper is the selective banning of OTT communication services. Till now, the government of India has been ordering internet shutdowns under the temporary suspension of telecom services, public emergency or public safety rules 2017. Under these rules, the government has the right to order internet shutdowns in specific areas of the country for public emergency or public safety reasons. What TRI has asked for comments is also to understand if there is a possibility to look into a legal framework where only selective banning of certain OTT services can be done, such that where there is a risk of fake news or hate speech in relation to a public emergency or public safety situation, only those communication services could be shut down without affecting other services like EdTech, enterprise softwares, e-commerce, etc. What TRI also wants to understand from its stakeholders in this regard is whether there are any technical challenges and also the legal framework around making such orders. So overall, a very interesting proposition that TRI has made, and in terms of their consultative process that will kickstart now. What will also be interesting to see is the interplay if TRI does go ahead with its, after the consultation process, it does make recommendations to the DOT, then the interplay of its recommendations or DOT's regulations with the forthcoming Digital India Act, which will overall regulate the digital space in India. So that's something that will be interesting to see and look out for. The next segment is on the Cinematograph Amendment Act, which got passed recently by the Parliament. Again, to give you a brief background on Cinematograph Act in India, it regulates theatrical release of films in India and has established an authority called the Central Board of Film Certification, which certifies various films that get theatrically released. The amendment has had a very interesting journey. There have been several consultation processes, 2 expert committee reports, one previous iteration of the amendment, and now the final Amendment Act. To give you an understanding of the key changes that these amendments make is as follows. So the first one is that the age rating, which was previously universally viewable by all audience, A, which is only for adult viewing, UA, which requires adult supervision or parental guidance, and S, which is for a specific category of persons. Under the UA category now, the Act requires producers and distributors to create a further age marker for UA 7+, which is for children above the age of 7 years and under 18, UA 13+, which is for children above age of 13 and under 18, and UA 16+, which is for children above 16 and under 18 years. In addition to this, there used to be an earlier provision where the central government could re-examine any order or any certification by the CBFC, which is the censor board, and revise that or review that decision of the CBFC. That has been done away with to great relief of various stakeholders, producers, and distributors. And instead of that, there still exists a provision where in case of very limited grounds, the government may order certain certifications and age ratings to be revised at certain points of time. On the operational side of things, the validity of the CBFC certificate has been increased from 10 years to perpetuity. Again, great relief to film producers and distributors, since they don't have to undergo the operational and monetary burden of revisiting their certificates and having them extended again. Interestingly, certification for television has also been dealt upon in this Act. Any film that is certified as A or S has to be recertified before being theatrically exhibited, in which case the CBFC may again order further cuts before it can be shown on television. The provision can also be extended by the government to additional mediums, which currently would mean OTT platforms. On this count, because the IT Act provides OTT platforms to self-regulate and provide their own age ratings, it may create certain conflict. Between the IT Act and the CBFC's ratings, and will have to be seen how it will be dealt with and how the two acts will interplay at that point of time. After a lot of stakeholder consultation, piracy has also been dealt with under the Act. In addition to the copyright infringement remedies and remedies under the IT Act, where a platform can be asked to take down pirated content, piracy has also been made an offense under the Cinematograph Act. Very stringent penalties have been suggested, which may extend from 3 months to 3 years of imprisonment and a fine of 3 lakh rupees to up to 5% of the audited gross production cost. This also is a big relief to production houses and distributors because a large chunk of their revenue still comes from theatrical exhibition. The Act also goes forward and says that any platform which does not comply with the IT Act provisions and therefore cannot avail safe harbor can be acted upon by the central government. And therefore, it creates a very unique web between the 3 acts, which is the Copyright Act, the IT Act, and the Cinematograph Act, where remedies are available for piracy under all 3 to the relevant copyright holder. So all in all, a very good development on the production side of things.
Great, thanks, Ishan. But I think before we wrap up this, a quick question. Under our IT Act and IT rules, there's also a certain prescribed way of how age rating should be done for content on digital side of things, right? Now, when this comes into effect, how does both of these interplay together?
So you're right, Tanu. Currently, the Cinematograph Act does not refer to OTT or digital ratings at all. It currently only limits itself to television, but there is that flexibility where government may require OTT platforms also to start confirming, at which point the self-regulatory mechanism will take a sort of a hit in that sense. And it seems that OTT platforms will have to comply with with CBFC's ratings. Also, just one more thing to be noted, that this will be only for content that first gets released to theaters and then comes to OTT platforms, and not for direct to digital content.
Great. Thanks a lot, Ishan. We'll move on to our next segment. Nishad will talk about guidelines in the advertising space. Over to you, Nishad.
So thank you, Tanu. So I'm audible, right?
Yes, audible.
So the Advertising Standards Council of India is a self-regulatory body which governs advertisements in India. Now it has issued what is known as the Comprehensive ASCII Code, which comprises of various guidelines on various aspects of advertising in India. Now, ASCII in the last couple of weeks has released its guidelines on advertisements for charitable causes, and has also released some amendments to its guidelines on disclaimers which are used in advertisements. Let's look at the guidelines on ads relating to charitable causes first. Now, ASCII recognizes that charitable organizations assist in crowdfunding for beneficiaries who might not have access to donors. Now, ASCII appreciates that these organizations need to appeal to the sensitivities of potential donors through advertisements, which help them make informed decisions to support these specific causes. However, you would have seen that most of these advertisements contain disturbing images which have potential to cause unnecessary distress. Now, this is one of the reasons why these new guidelines have been published. The guidelines seek to protect both the beneficiaries as well as the potential donors. Now, for the beneficiaries, the guidelines require that whilst using images, organizations should bear in mind the dignity of beneficiaries and should not show graphic images, especially of children and minors. Express consent must be taken before displaying these images of beneficiaries. From the donor's perspective, disturbing images must be blurred, and the consumer or the donor must have the option to watch it or not watch it. Similarly, where charitable organizations charge a percentage of the collections as their fee, or are likely to use some part of these donations for a cause other than that of the beneficiary, these details are required to be clearly disclosed to the donors upfront when these advertisements are being made. So these are the short guidelines on charitable causes. Let us now look at the amendments with regard to the disclaimer guidelines. The ASCII code already contains guidelines for inserting disclaimers in advertisements. The guidelines have been prescribed so as to ensure that any broad product claims, which can be misleading in nature, are not qualified by disclaimers. The guidelines presently set standards for the language to be used, the font size, the placement of these disclaimers, the speed in which they should be shown, the legibility, etc. And the intent has been to ensure that the disclaimers are clear, prominent, and legible for a normally sighted person who is reading the marketing communication from, say, a reasonable distance and at a reasonable speed. Now, ASCII has over a period of time received feedback in relation to these guidelines, and in view of these feedback which they've received, they've issued some changes and clarifications. Now, firstly, it is clarified that these guidelines shall apply only to that content which relates to the product claim. So these guidelines do not apply to the display of any other information on the screen when the advertisement is played. So there may be certain regulatory requirements which require certain disclaimers on the screen. These are not covered. Only product claims are covered. The guidelines now recommend that product claims should be made in a manner that they are clear and require minimal or no disclaimers. The guidelines prescribe that only one product claim should be made per frame and only one disclaimer should be displayed per frame. Similarly, such disclaimers should not exceed 2 full lines and should be displayed at least for 4 seconds. Similarly, the disclaimer should be displayed with a hold period to be calculated assuming a reading speed of 5 words per second. The longer the disclaimer, the larger the size, the larger the holding period there. The guidelines specifically state that the language used in the disclaimer should be simple language so that they can be understood, and should use words and phrases which are simple, direct, and user-friendly. So the changes are really clarificatory in nature, don't really add too much except for certain particulars. That's all from me. Back to you, Tan.
Thanks, Nishad. I think Jay has a question on the chat box. What mediums do these guidelines apply to? Is it, agnostic of what medium ads are playing on, or is it limited to a certain distribution medium?
Yeah, so they apply to all media, of course, because advertisements are broadly covered under the ASCII code, and they are across the media or across the platform that they are published on. So yes, it's all media, all platforms.
Right, great. Thanks a lot, Nishad. Thank you for that. Our next speaker and our final segment for today, Sumantra will talk about the cybersecurity space. Over to you, Sumantra.
Thank you, Tanu. Hi, everyone. So I'm going to cover the recommendations of the Parliamentary Standing Committee on Finance regarding cybersecurity and rising incidents of cyber and white-collar crime. What I'll try to do is I'll cover a bit of background on why the report, and there are 5 major limbs of the recommendations, of which I'll try to cover what's the lacunae that they have identified and how do they propose to fix the lacunae that they have identified. And towards the end, I will finish with possible legislative and business impact going forward. Interestingly, the Standing Committee consists of members of the Ministry of Finance, the Ministry of Home Affairs, as well as the Ministry of Electronics and Information Technology, and therefore signifying much greater coherence amongst ministries to come up with more compact and comprehensive legislation in the present context, of course, it being cybersecurity. One of the key reasons why this report has come into being is the ever increasing incidence of cybercrime, particularly in the field of financial transactions, which went up manyfold during the pandemic and afterwards. Now, just moving to the first limb of the recommendation, what the Standing Committee identified is that even though there are several laws and regulations on cybersecurity, there are clear points where much more needs to be done from a regulatory effort. One important aspect that they have identified is the responsibility of app stores, who should perform greater diligence and understand the nature and identity of the developers and the sort of applications that are being hosted on the platforms. Of course, the reason for this being that there were several applications who were engaging in various practices, unethical practices of digital lending, for instance. Moving on from this, the second limb of the committee report is that while there are several regulators, such as the Indian Computer Emergency Response Team, the RBI itself, which is a number of regulations, there is a lack of authority who can effectively engage all these authorities and come up with proper standards on cybersecurity. And therefore, the committee has recommended the formation of a centralized cyber protection authority. Legislatively, what this means is that this cyber protection authority will be responsible for coming up with even more standards. One important part that they have identified on standards is that the financial system is currently dependent on several service providers, whose criticality is sometimes undermined, but they play a great role in the ecosystem. And they've also identified that any sort of time while these service providers are unable to provide their services can have a great impact on the way the financial system works. The third limb, of course, is on grievance redressal. One important thing that the committee has identified is that very often individuals do not even know where and how to make claims when they're victims of cybercrime. Important recommendation that has come in is to completely change the nature of grievance redressal, compensate the customer first pending further review, and then figuring out how to resolve the incident. The last 2 points are more regulatory, regulatory within the ministry, that is local enforcement, that there should be a single point of contact for each district police department. The committee has also identified that there are several best practices across other jurisdictions, and they have outlined a few of them, which the regulators and the future regulator can take into note. Now, just capping off in terms of possible legislative impact, in terms of what I already mentioned, that we expect far greater regulation for entities such as app stores. This could be in the form of the upcoming Digital India Act, which has found a mention in the committee report. We will also likely see more cybersecurity standards for the vast majority of service providers. The RBI has already moved in this direction, but we expect a lot more based. Right. With that, I will hand this over to Jay.
Wonderful, thank you. Since Sumatra, since I have you on the screen, if you could just stay on, I have a question for you, sir. But I really would like to see if our participants at this point have any questions. If you do, raise your hand or come on screen, and it's a great opportunity to ask our experts. The first thing I want to say is I just want to congratulate the Khaitan team. I mean, once again, you guys deliver really excellent presentations, in-depth and insightful information. I cannot say it enough that I think what you're sharing here and now goes a layer deeper than what we often hear. So I really want to thank you for that. We have a question. I'm going to start with Hemant, over to you.
Hey, hi, gentlemen. I think it was very insightful one. I'm kind of a little skeptical on the adoption and enforcement of this bill, because the public awareness, at the scale which was required will take some time. I do not know what would be a view of the, speakers at this point of time, while it is too early to, think about how can the strategies to make the adoption at the mass scale, done in India. Thank you.
Thank you, Hemant. Which bill are you talking about? We've discussed several. Data protection bill?
So I'm talking about the recent data protection bill.
Yeah. Okay.
Right. Thank you
Super team,
so
over
much.
to you, sir.
Yeah, thank you so much for the question, and completely agree that from an Indian preparedness and mindset perspective, I think we need a lot of education at every level. I think the government has certain thought process in mind, but I think we as a community, we all need to sort of come together and do much more. Till the last person on the floor is not educated on data privacy and protection, I don't think that we would have done justice. I keep giving this simple example. We had a situation, two situations actually, when we were doing a hotel related GDPR exercise. And one was that we were checking into a hotel, and there was a quick check-in counter. There was a laptop kept, and right below the screen, the password was written on a post-it and pasted. Okay. And the second one was that the hotel was trying to find out how many people from EU had come there, and they found out a lot of people from Afghanistan were there, right? So, and the reason was that there was a drop-down menu. The first name was Afghanistan, so everyone had been tagged to Afghanistan. So, if you have that kind of data, it will be very difficult for you to even do data mapping when you're setting off with this particular new law. And the second thing is education. To the last person who's operating and handling this on the floor, education needs to go to at every level. So agree with you completely. We need to do a lot.
Just related
Wonderful,
to this,
thank
I
you.
wanted to just
quickly get your thoughts also on whether you have had the chance to compare it with the EU GDPR, and incrementally, what do you think a multinational company operating in India compliant with the EU GDPR, incrementally, is there anything that they need to be immediately focusing on?
Yeah, so I think, yes, incrementally, we are actually putting together a paper. Maybe we'll circulate this to the group as well. Shobit has been instrumental in anchoring that particular exercise for us. There's a lot to do. I'm talking about very fundamental things like age of consent is 18 years in India still now, right? It's 16 years in GDPR. It can go below up to 13 years depending on member state. The DPO. Right? It's fundamentally different. They are talking about DPO doing grievance redressal related work here. Right. So all those things, I think there are a number of things which are quite different, and we will talk about that in the paper. Maybe, after that, we can have another session later on the comparison with GDPR.
That's great. I look forward to it.
Thank you. And if you can add in adequacy into that question, I think that's going to be one of the really big issues, whether or not this bill would meet EU adequacy. Also, I think you referenced capacity building. I think that's going to be critical. Once the bill's passed, we're going to move into a phase where I do think there's going to be a lot of rulemaking, a lot of details. But in order to make those rules and make good policy and regulation, there's going to be necessary capacity building. And if you talk with any privacy regulator, even people that are very experienced, the one thing they very often say is things change really quickly, and constantly the regulators are behind where the market is. And so that capacity building, I think, is an ongoing activity, but certainly within India, there's going to be a need for a cadre of new officials that are going to need to step in and regulate and process a lot of paperwork and applications and other sorts of rulemaking activities. So thank you for that. We're going to go over to Bikas. Over to you, sir.
Yeah, I'll be very quick. So this again goes to Supratim, to you. So two things. One was a clarification. I mean, you did mention that every consent will have to be taken in 22 languages. The way I read it, I thought that it could be any of the 22 languages depending on the data principle. So if you could clarify that. Second one is not a legal question, Supratim. So it's basically just wanting that to know that do you think the way they have treated data that has been that has already been captured prior to whenever the law becomes an act, there are certain provisions and certain directions towards that. And do you think that there is a possibility of government rethinking that independent regulations that were drawn for data localization? Do you think that will be relooked at, or are the agencies like an RBI or others too independent to really come under that? So not RBI, but let's say the company, Ministry of Corporate Affairs would think it. That's slightly speculative, but nevertheless, if you could try, I will be grateful. Thank you.
Thanks. Bikas was coming in and out, but I believe the question was twofold. First and foremost, is consent required in every official language, or one or that? And then what happens with retrospectively? Do you need to get consent, and how does data in the system, how is that already handled?
Right. Thank you, Jay. I think you also raised the first question, and the way we are reading it, that this option of reviewing the notice and the consent in 22 languages has to be given to the data subject or data principal. Therefore, to our mind, it's not an option. It's something that you have to anyways pre-prepare and keep. Once the data subject is asking for it, you'll have to provide that. That's number one. Answer to the second question is that we don't think that there'll be any retrospective action carried out. And I think they have kept it fairly simple. If there is a consent which was taken before this particular law came into play, what you need to do is, as soon as reasonably practicable, you need to send out notices as to what kind of data you are handling, and the purpose for which you are handling. And now there are some additional requirements, such as the data subject has what kind of rights they have, and they can approach the data protection board in case required. So these are fairly simple. I think this is also a learning from GDPR and the likes, where there were a lot of players who sent out consent related mailers, and what we saw is, suppose 2 lakh were sent, not even 200 reverted back. So probably this is a slightly business friendly approach, and therefore it's not a re-consent, it's just sending out notices once the new law comes into play.
Great. Mira, over to you. I'm hoping that we pull in all the different topics as well. So over to you, Mira.
Okay. So, Jay, this is again pertaining to the DPDP bill. I'm sorry, I couldn't bring in a variation.
No worries. Go ahead.
So my question is, given the stringency around, consent, how does the practice, or like forensics, how are they going to be able to operate under the new law?
Yeah. No, I think this is already, there's already a lot of flutter in the market on this. There was a clear, leeway which was provided, earlier deemed consent, that set of items which were provided, which said that, they have a leeway that has been deleted right now. And therefore, the way we are observing is probably, we will have to see if some of these institutions will have to go for that exemption specifically, because some businesses could just become quite, difficult to operate post coming of this bill. So you are right.
Thank you.
Great, thank you. I'm going to go to Sumantra, and I'd ask for some non-privacy questions just so we can cover off all the topics. So Sumantra, when you were talking about cybersecurity in the financial sector, the thing that jumped out at me when I saw your slide was the US NIST cybersecurity framework. And a lot of the topics that you raised, many of them seem to be addressed to a certain degree in the NIST cybersecurity framework. Is anyone in India talking about the NIST framework? I know several international countries, Japan and Israel and others, really have embodied, I think, a lot of the good work, multi-stakeholder aspects, risk-based, sector profiles, all of that stuff. Is anyone talking about NIST in India?
Not really. I think there's not too much of convergence on what kind of framework would work. In terms of the committee report itself, they've identified certain best practices, but I think there's a fair way to go in terms of, in fact, the report itself talks about several regulations that are already in place, several standards that are in place, and the fact that they're talking about more standards to come in, I think a lot more engagement in terms of, and the report also identifies that engagement with other regulators and frameworks which can work, which have worked internationally, can also work here. I think a lot of work can happen in that direction.
Great, and I'd encourage people to look at that NIST framework. I mean, there's a lot of sector profiles that I think could do a lot to support the development and capacity building within India's arena. And I think it's an opportunity to educate Indian decision makers in government and elsewhere that a lot of work has been done. So maybe we shouldn't recreate the wheel. The NIST framework is a wheel, by the way. We shouldn't recreate the wheel when so much really good work has been done that also includes multi-stakeholder activities, industry, academia, and whatnot. Great. So there's one more question that I think I saw. Hemant, over to you.
Hey, thank you, Jacob. This one is quick as an extension to your recent NIST conversation. And this question is specifically to you, Jacob, and to Supradimda. do you see a significant opportunity for a public-private partnership in India when it comes to establishing a judiciary framework or enforcement framework, when it comes to the adoption and, the adoption of digital personal data in India, where the NIST kind of frameworks, which are already matured in the US, they have gone through a full cycle, right? So instead of reinventing a wheel, whether a public-private partnership in establishing a fresh new judiciary and enforcement for digital, data, framework in India, that will be probably accelerating the whole efforts that everybody is trying to contribute.
I think that's a great question. I'll see if our colleagues from a Khaitan company have a response. But after NIST launched its cybersecurity framework, and they're launching an update of it at the end of the month, the end of the year, by the way, they started a process to create a privacy framework using the same sort of multi-stakeholder risk assessment, profiles, and so forth. And the long-term plan is to mesh the cybersecurity and the privacy framework. Just to be clear, the framework is not regulatory. They are tools that are developed and used by different stakeholders to promote the objective, cybersecurity or privacy. So they are separate from regulation. But I would love to hear from our experts here as well.
Right. Thank you, Jay. And just one aspect to add here, I think the way we have observed the government play this out, I don't think right away they would be very keen to put any framework, at least formally, in the document, in the rules, etc. That, if you follow this, this will be good. Probably it will evolve over time, and some leeway would be given to industries to evolve these in their own industries, etc. Formally calling out something immediately seems to be a little unlikely.
Great, thank you. Absent any final questions, if members have any questions, raise your hand or put in the chat. I'd like to pull in some of our other experts, but I also want to give us some context. When I was listening to you all, I sort of heard 3 or 4 contextual activities or commonalities, but a little bit at cross purpose. So one is to update and reform regulation. But when we heard that, we also saw the promotion of new digital regulators, a new data protection board, a new AI, and a new cyber regulator, in addition to existing. Beyond that, we also saw a bit of a desire for ease of doing business and making India competitive and attractive, but then we also saw sort of that counterbalance on taxation and so on. So I want to, start with, Sudipta and ask you, clearly India is promoting the gaming industry, but then they're looking to tax it. How are businesses thinking about this? Have you seen a noticeable impact in new investment, new companies, or contrary, financials or anything like that? How is this impacting business? Obviously, it hasn't hit yet, so it's not real, but it's forward-leaning. And has it had any impact? Sudipta.
A good point, Jacob, on that. There is a fair amount of, I would say that investment has hit a pause button, especially when we are talking about the real money gaming segment of the gaming sector. E-gaming as a segment, I think they are probably more relieved while they have filed a representation to have a formal clarification that these don't apply to e-gaming or where there is no money wagering happening on the outcome. I think that's fairly clear from the law, but I think the real money segment definitely there's a massive impact. In fact, as we spoke in the course of the last 30 minutes, I've just had a update on my mobile that one of the very prominent real money gaming, maybe the number 2 or number 3 in that segment, they've just announced that they will be forced to lay off 50% of their workforce. So, tragic as it is, I fear that there will be more such news as we go along, especially from relatively smaller players in the real money gaming segment. So, a lot of representations, including from the top investors in this sector, both domestic and international, the top players, all of them have written repeatedly to the government and to various state governments. One hopes that this will be reconsidered. But for now, clearly it seems that the government has taken a position against real money gaming. I mean, that small segment, or not a small segment, but that segment of the overall gaming ecosystem.
Great. Well, thank you. You know, they say that time flies when you're having fun, and I'll add time flies when you have real substantive conversations. And we are over time. I want to thank the Khaitan Company team. I want to thank our participants as well. Sudipta, Super Team, Shobit, Nishad, Samantra, Ishan, and of course our moderator, Tanu, and also Ravina on the back end. I know a lot of people put a lot of time into developing this material. We will make it available to our members. And if you have any questions, I'd be more than happy to connect you with the team. And you can see an email up here on the US desk at khaitanco.com. Or if you want a more personalized introduction, please reach out to the USIBC team. With that, I want to thank you all. Have a good evening, a good day, and a good night, depending on where you reside. Talk to you all soon, and we look forward to our next iteration of our monthly digital roundup. It's always insightful and valuable, so thank you again. Bye for now.
Bye-bye.
Thank you.
Thank you.
Great job for the Khaitan.